Are you serious?
This matter is concluded. You're free to go.
Who's sucking whose dick around here? No, seriously.
Another 30 days for contempt of court. You're in jail for 60 days. Good morning to everyone. This time and place set for the show cause hearing in this matter for contempt for failure to provide parenting time. I'll let you know we're going to take some brief, testimony from the parties. I'll let everybody know that everybody will have an opportunity to speak. So don't interrupt anyone else or don't interrupt the court. You'll have an opportunity to speak your piece. So
this case doesn't start calmly. It explodes. What you just heard is actually the outcome of a courtroom battle filled with tension, serious accusations, and repeated defiance of court orders. On one side, a father fighting to see his children. On the other, a mother insisting she's protecting them. But here's where it gets complicated. The timeline, the contradictions, and multiple ignored rulings. This isn't just a disagreement. It's a pattern. And by the end, that shocking moment will make complete sense.
We do have the show cause hearing. We also have the motion for change of custody and parenting time. I'm going to address the motion first because that will be the easiest matter to get resolved. So, Mr. Kelly, you can proceed with your motion.
Your Honor, essentially, that motion is based primarily on the issues we've had ongoing in relation to compliance with the court order and my client getting parenting time. It's directly and impacts the child custody factors, and I'll name the ones that are impacted due to this withholding occurrence. The love, affection, and emotional ties existing between the parties. It looks at the emotional bond. Him being prevented from seeing his kids is preventing him to continue that emotional bond and nurture that emotional bond, which he had prior to this latest withholding that has started back on December 27th. Factor B, the capacity and disposition of the parties involved to give the child love and affection. That focuses on the ability to, again, parent to foster an emotional bond in the future. He's having a hard enough time in the present, again, because she's not keeping in compliance with the court order, and he's not able to see these girls to be able to have a solid relationship and foster that relationship. The length of time they've lived in a stable, satisfactory environment, I'd submit to the court, defendant's home is not stable, considering the allegations she's made that have been investigated by CPS twice, police twice, and both been denied. Nothing's come of it, which leads me also to the moral fitness of the parties involved, which ties into the same factor. But we have to keep in mind, Your Honor, at the beginning of this case, he was charged with domestic violence in relation to her essentially going after him to get keys to his truck so she could get some pot and smoke it. As he's being arrested, she's telling him, "I want you to come home." He, of course, gets him on bond. He can't have any contact. Once the bond conditions get lifted, she's contacting him through text and saying, "Hey, let's meet you and the girls get together and we can go to the zoo or we can go to a park."
The judge immediately sets control. No interruptions. Everyone gets a chance to speak. That matters because this case is already emotionally charged. Also notice the strategy, addressing custody first. Why? Because if custody shifts, everything else changes. So the real question here is this just about missed visits or something much bigger?
Okay, Mr. Kelly, how does this relate to your motion?
It's related to, Your Honor, again, the moral fitness involved, as well as the stable, satisfactory environment, in that she's accusing him of sexually molesting these girls. But before all this, she's wanting him to come home. She's wanting a relationship with him. She's wanting her family essentially reunified. Those two things don't jive together, Your Honor. And I would think that essentially it's a fabrication, which would go again to the moral fitness and also to the mental and physical health of the parties, Your Honor. You're making these allegations, these terrible allegations, but on the other hand, you're still wanting the same guy who's supposedly doing this stuff to come into your house. Finally, Your Honor, the unwillingness and ability to facilitate and encourage a relationship. Again, this is the fourth motion we're here this morning on, Your Honor, for him to see his girls. She doesn't follow your court orders. She withholds them for no valid reason. And she's clearly shown she's not going to facilitate a relationship between him and his kids. I think that's more than enough that gets us over the threshold of a change in circumstance or proper cause, because these things are having a significant impact on these girls' lives in terms of having a relationship with their mother. So we would request, as part of our relief, that you set this matter for an evidentiary hearing. We're also requesting during the interim that my client get temporary parenting time starting today, and that he continue to have them until the evidentiary hearing, that mom's parenting time be supervised at her expense, because she's clearly shown an unwillingness to follow your rulings or to comply with your court orders. I think if you don't do that, she's going to take these kids and run, and we're going to be in a bigger mess than we are today.
Okay, thank you.
The father's attorney builds a structured argument using key custody factors: emotional bonds, stability, and co-parenting ability. But the biggest point? A contradiction. Serious accusations are being made. Yet at the same time, there were attempts to maintain contact. In court, that matters, because credibility isn't just words, it's consistency.
Ms. Couch, if you wish to speak to the motion.
I had some statements, but it's just what I had submitted to the court.
Okay, go ahead, tell me, and then
Okay. Would you like me to stand?
whatever you wish. If it's more comfortable sitting, go ahead, but speak up a little. So
Okay. I said that his first statement was true, but the second statement that he said was false. I said I previously tried to change parenting time because of the videos the plaintiff had been watching. It was reported to Penfield's police department because plaintiff was previously residing in Penfield. I spoke to their sheriff where we looked at the videos together, and he told me that he would be conducting a search and not to address the matter to the plaintiff because he would need time to get 2 search warrants, and the investigation was never done. The next statement is also false. On December 27th, after the children's bath, Amelia Conley was heavily touching her private area, and when questioned who touched her potty, she said her dada. On January 1st, Evelyn Conley stated that her dad touched her on the couch. The fourth statement is false. CPS is not taking the proper steps to ensure the minor children's safety, and I did mention police involvement in the last hearing as well. The fifth statement is also false. Errors were made by the plaintiff's attorney.
Now the mother speaks, and the tone shifts. She raises serious concerns about the children, referencing behaviors and alleged incidents. But here's the issue. Court decisions rely on verified evidence. And as she speaks, there's a gap between claims and confirmed findings. So now the court is facing 2 completely different narratives.
The sixth statement is also false. There is supposed to be a pending CPS case, and I was never told otherwise. CPS and I have spoken on numerous occasions and decided that the best course of action was therapy, which the minor children are attending at Summit Point. I do have proof of all of that as well. 7, that's also false. I was never told that they were declining to investigate the police. Number 8, it's false. In early 2024, my mom threatened to call CPS on me because of the children's odd behavior, requesting that I get them checked by the doctor. I had the doctor examine them at their 2-year checkup, and almost 2 months later, the plaintiff was arrested for domestic violence. I originally withheld the kids because of the plaintiff's sexual preference for diapers and enemas, knowing that the plaintiff was not mentally stable enough for unsupervised visitation. And I withheld the children again after finding videos the plaintiff had watched of children being abused. And the minor children were sexually abused during holiday parenting time with the plaintiff. The 9th statement is true. The 11th statement is false. The 12th, I'm unsure of the plaintiff's employment, but the plaintiff has stopped paying child support, and I still stay at home with my children. Number 13, I have lived at the residence that the FOC has on file since December 10th, 2024. The 14th statement, I'm unsure of the plaintiff's relationship status. I have friends and family in Michigan, and I lived in Indiana until I was 18, and most of my family resides there. Number 15, I would like the court to consider changing the current custody orders and issue no further contact between the minor children and the plaintiff. Plaintiff should be held accountable for his actions, regardless of stature or representation. That's all.
Okay, thank you. I don't need.
This is a turning point. The judge decides there's enough to move forward with a full evidentiary hearing. That doesn't mean a decision yet. It means the situation is serious. But at the same time, the court shifts focus back to one key issue: compliance. Because orders still have to be followed.
Anything else, Mr. Kelly? What the court will do in this matter is the court has read the pleadings, obviously is well aware of the file in this case. The court does believe that the plaintiff has met the VARCA threshold of proper cause, change of circumstances sufficient for an evidentiary hearing. So the court will schedule an evidentiary hearing in this matter. Mr. Kelly, you can proceed with your show cause hearing. Do you wish to take testimony from your client? Okay.
Certainly can. I have another witness that I could call as well. I just had two.
Okay. Whichever you want to do first. Go ahead.
I could have Mr. Connolly
Okay,
testify.
Mr. Connolly, if you step forward, we'll have you sworn in and then we'll take some testimony. And I say brief testimony. I don't need to get into.
Sure. We'll keep it straight and to the point here.
All right, raise your right hand, please. Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Sir.
Go ahead and have a seat, sir. Go ahead, Mr. Kelly.
Mr. Connolly, could you state your name and spell your last name for the record?
Zachary Donald Conley, Conley.
Are you the father of Amelia and Evelyn Connolly in this matter?
Yes, I am.
Okay. You currently have parenting time with them.
Yes.
What is your understanding of what the parenting time is supposed to be?
Every other weekend and a day during the week, in the evening. On not my weekends, it's Wednesday through Friday.
Now we hear direct testimony, and a pattern becomes clear. The father says he repeatedly tried to see his children, but was denied every time. Even police involvement didn't change the outcome. At this point, it's no longer just conflict. It starts to look like consistent refusal.
Have you been getting your parenting time?
No,
Why not?
because she is refusing to let me see them.
And when you say she, who are you referencing?
Athena, couch.
Okay. Have you attempted to get your children from this couch?
Yes,
Have you called the police for their assistance?
yes.
What happened when the police got involved?
That she slammed the door in their face, denies them, and just tells them no.
Have you filed motions with the court to get parenting time?
Yes,
Has the court awarded you make up parenting time?
yes,
Most recently, did the court award you parenting time in January of this year?
yes,
Did you attempt to go pick the children up for that make up parenting time?
yes.
What happened?
She refused to give them to me again.
Do you approximately know how many days you have missed so far as simply your overnights for parenting time?
20.
Would you like the court to grant you some make up parenting time this morning?
Yes.
No further questions, Your Honor.
Okay. Ms. Couch, do you have any questions for the plaintiff? No? Okay, thank you. You may step down then, sir. Next witness, Mr. Kelly.
Your Honor, we would call Lori Connolly.
Okay, Ms. Connolly, step forward, please.
The grandmother's testimony backs up the same story, and that's important. She describes a clear shift. Things were normal before, then suddenly everything changed. Repeated refusals, no cooperation, even with police present. And when testimony stays consistent across witnesses, it carries serious weight.
Lori Putnam, Your Honor.
Okay. You're gonna make me change my.
All right. Ma'am, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Ma'am, could you state your last name again?
Putnam, Putnam.
Okay, thank you. Go ahead.
Ms. Putnam, how do you know Mr. Connolly?
He is my son.
And how do you know Ms. Couch?
She is Zach's former girlfriend and the mother of my granddaughters.
You heard him just testify that he has parenting time with your granddaughters, correct?
Correct.
Okay. Do you assist him in pickup and drop offs for
I
parenting
do.
time? Okay. What do you do in that regard?
I go with him and walk up to the door with him to get the girls,
Okay.
to attempt to get the girls.
Has there been occasions when you have gone with him to go get the girls? And anything happened in regards to him actually getting the girls?
Prior to December 27th, yes. After December 27th, no, she refused.
Let's talk about prior to December 27th. What would happen?
We would go, then we were meeting at Riverside Park, and we would wait for her to show up. When she'd show up, she'd let the girls out and they would come running up to Zach and we would take them.
Okay. Did something change after December 27th?
She just started refusing to give the girls. His first visit that he was supposed to was, I'm not sure, but I got a text from Athena on New Year's Day saying
Okay.
that she was going to refuse to give the girls.
And have you gone with him on subsequent occasions to attempt parenting time?
Yes.
Okay. And what has happened on those subsequent occasions?
Either she would not be home, he would text her and she would not respond, or if she was there, we'd knock on the door, she'd open the door and then just say no and slam the door in our face. So we would go back to the truck and call the police for the police to come out and assist.
And the police came out and assisted. That help in terms of actually getting parenting time to occur?
No, she just did the same thing to the police.
No further questions.
Okay, hold on, ma'am. No, you're not done. Just to clarify, that he talked about prior to the December.
In the end, the judge focuses on one thing: repeated failure to follow court orders. No matter the claims, the law requires compliance, and ignoring multiple rulings has consequences. That's what leads to the final decision, and that explosive moment you saw at the start. If you found this case as shocking as we did, hit like, drop your thoughts in the comments, and subscribe for more courtroom breakdowns.